I'd like to introduce our next speaker. He's Professor Sonu Gaind. He's a professor in the Faculty of Medicine at the University of Toronto and the Chief of Psychiatry at Humber River Hospital. He's the co-director of the University of Toronto Adult Psychiatry and Health Systems Division, and a university governor and honorary member of the World Psychiatric Association. He's an executive member of the Ontario Medical Association section on psychiatry. He chaired the Canadian Psychiatric Association Task Force on Assisted Dying, was selected to sit on the Council of Canadian Academy's expert panel on mental disorders and assisted dying, and he's spoken across the country and internationally on the subject. And he will review the Canadian experience and explore the medical, legal, scientific, ethical, and public policy issues related to physician-assisted dying, focusing on the challenges posed by mental illnesses in the context of physician-assisted dying. Professor Gaind will discuss the role and sometimes the failure of professional organizations bringing forward evidence-based considerations to public policy consultations. He will also explore differences between groups seeking the legislation of physician-assisted dying and discuss potential impacts of expanding physician-assisted dying laws on marginalized populations. Professor Gaind.
Thank you, Dr. Clark. I appreciate the opportunity to speak with all of you today and for this kind invitation. I'm just going to share screen if I can. Just give me one moment to get the proper one going. And if someone could then just flag for me that it has actually worked. Dr. Clark, is that coming across okay?
You're fine there, yeah.
Yeah, okay, great. So thank you once again for the opportunity to speak here. This is obviously an emerging and evolving issue, and sometimes it moves much more rapidly than anyone might have imagined. I will give my disclosures here. I don't have any conflicts of interest and certainly no financial conflicts, but when we're talking about policy, I do think that outlining the different roles and potential backgrounds that people have is important because we might bring those views into policy discussions in transparency. So I have sat on several expert panels and testified in front of our Parliament on this issue. I have been retained by the Attorney General of Canada in 2 of the cases, one of which did go to court, the other one did not end up going to court. And I chaired the former Canadian Psychiatric Association Task Force on Assisted Dying. I will say that I'm not a conscientious objector per se. In fact, I actually chair my hospital MAID team. However, I have come to have extreme concerns about the expansion that we are having in Canada. And the goal for today will be to outline not just what's happened in Canada, but to a large extent, a cautionary tale, I would say, for the rest of the world, and to understand the different frameworks, but the different ways that those frameworks can affect different people. And this objective at the end, the tension between over-inclusion and under-inclusion in the context of potential assisted dying, I believe personally that that is one of the fundamental things that's often lost in these discussions. I've certainly seen that happen in Canada. It was fascinating for me hearing Justice Kelly's legal overview. We have certainly many parallels in Canada with different outcomes. And Justice Kelly, I'm glad you're staying on because I will warrant that I will change your opinion on one thing. In fact, I would wager on it. But in terms of the legal background, suicide is not an illegal act in Canada. It had been an illegal act in the criminal code to assist someone with suicide. And that's what this legal challenge came up against. So this was the Supreme Court ruling that's triggered all of the things that have unfolded in Canada in the past few years. From 2015, it was a ruling involving Kay Carter, who had spinal stenosis, and Gloria Taylor, who had ALS. And just in parenthesis, I'll point out there that these things are important because you'll see that many of the rulings have very specific sorts of medical issues before them. Predictable neurodegenerative ones, for example. None of them in Canada have had mental illness as something that's been looked at. Now, what this ruling found is in a unanimous 9-0 decision, the Supreme Court ruled that the up until then blanket prohibition against assisted dying violated our Charter of Rights and Freedoms. This was very different than a ruling from 1993, which was a split Supreme Court decision that upheld the very same law in a different case, the Sue Rodriguez case. So what's our charter say in Section 7? It's the section that speaks of life, liberty, and security. And what some people are surprised to learn is that the judges ruled that all three of these were violated by the blanket prohibition, including the one on life, which raises some questions, but the rationale went this way: that if somebody is in a state of intolerable suffering and predictable decline, and they can anticipate getting to a point where they will no longer be able to physically act to end their lives, they may choose to end their life before that time. And that period of foreshortened life, they felt, was a violation of the right to life. Now, I would ask you to think about, and this is where we start to see differences that emerge in mental illness versus other things. Mental illnesses can cause many things. At times, they can impact capacity, although most of our patients retain legal capacity for much of the time. But very, very rarely do mental illnesses lead to loss of physical agency. So this right to life, how would that play out for mental illnesses? People with mental illness do not tend to lose the ability to act physically, to take their own lives. Anyways, what ended up happening then in 2016 as a result of the Supreme Court ruling, we had Bill C-14 introduced, and Bill C-14 is the MAID framework that we had been working up until March of 2021. It has changed. So the initial framework had these 4 key components for determining if somebody had a grievous and irremediable medical condition. This was the fundamental foot in the door safeguard that MAID was supposed to only be for these sorts of conditions. And it was defined as a condition that was serious and incurable. Somebody's in an advanced state of irreversible decline. The next one I put in parentheses because this is unique to Canada. Nowhere else in the world has this, that the intolerable suffering cannot be relieved under conditions that the patient considers acceptable. There's nothing in here that says no prospect of improvement. Even in Belgium and Netherlands, there are things that speak to that. So in Belgium, I believe the term is medically futile. In Netherlands, both the physician and patient need to have the conviction that there's no other reasonable solution for a situation. In Canada, if a person deems that something might relieve their suffering, but they don't want it, then they qualify. And the other condition, and this is the one that's now fallen, is, or initially was, that natural death has become reasonably foreseeable. And there was no specific time frame provided on this. But in the cases that emerged over the next several years, and some provincial cases that were heard in courts, it was taken that that could mean even as long as 10 years away. So it wasn't anything where this natural death being reasonably foreseeable had to be, 6 months, like in some jurisdictions. It was actually very broad already. What happened next was in 2019, there was a Quebec court case, Superior Court case. I testified in this case on behalf of the Attorney General of Canada, and I was not in favor of the expansion that they were seeking here. But what this case challenged was that reasonably foreseeable natural death criterion. By the way, in terms of language, I have learned to prefer the word safeguard to criterion or requirement, because I do believe that all of these things are safeguards, and sometimes they fall away. This case involved 2 people, Jean Cruchon, who was 51 and had cerebral spastic paralysis since birth with tripartism, and also Nicole Gladue, and she had polio since the age of 4. And this was ruled by a single judge, and this case was ruled that the reasonably foreseeable natural death criterion or safeguard was overly broad, and that the country had a period of time to change their rules to get rid of that safeguard or criterion. And that's led to where we are now. These are the key changes from Bill C-7 in March of this year. Reasonably foreseeable death no longer is one of the safeguards. We now have 2 pathways. If reasonably foreseeable death is there, then there's no waiting period. So somebody could have a reasonably foreseeable natural death and they could get made later that week. If reasonably foreseeable natural death is not present, so this would apply for any disability, then there's a 90-day waiting period which can be shortened if there are specific clinical circumstances. And MAID for sole mental illness conditions is meant to be implemented in Canada by March of 2023 through what was called a sunset clause. And I'll speak on that later. And unique to Canada, as I mentioned, there's no requirement for treatment because the treatment needs to be acceptable to the patient. And this is where I'll challenge Justice Kelly. Justice Kelly, you suggested that Netherlands is the most chilling example of what can happen with expansion and the slippery slope. I don't believe it is anymore. I believe Canada is the most chilling example of that. This data is from our annual report from 2020. This predates the expansion we recently had. In other words, all this data is from the time period when natural death needed to be reasonably foreseeable. And what you see is that by 2020, fully 4% of deaths in Canada are attributable to MAID. If you break it down provincially, and this is what the next two slides will do, you'll see that there are significant variations. And this is not the slide from 2020, this is from 2019, to show you how these things have changed so rapidly in such a short course of time. That from 2019 to 2020, and this is the way the federal government phrases this, there was a growth rate of MAID of 34% across the country. 2019, by the way, in itself saw a 26% growth rate over 2018. So these are the provincial numbers from 2019. And you can see that some provinces, and that was back when our national death rate was 2%. Some provinces, Quebec was at 2.4 and BC at 3.3. And this is what's happened now. Our death rate is 2.5%, with Quebec at 3.1 and BC at 4%, again, prior to the expansion. And it has led to recent headlines like this: an entire province, Nova Scotia's medically assisted dying program, paused amid unprecedented demand. So what the rest of my talk will be about is what has led to this road to MAID expansion in Canada. And I will say that I think advocates on all sides likely come to issues with best of intentions, but paving a road with good intentions is not good enough. Our social policies should be informed by best evidence, not implemented while ignoring that. And I would suggest that, and this is despite my not being a conscientious objector overall, I would suggest that our path to expanded MAID in Canada has been more like the yellow broken road, not the yellow brick road. And it's been paved with myths and failures of due diligence. And that's what the rest of my talk will speak on. I'm going to go over 6 myths. Some take a bit longer, some take a bit shorter, so I will be mindful of the time. But in terms of the myths, and these are the myths that have guided our public discourse and actually influenced the different rulings, etc. The first one I would say is that mental illness is the same as other illnesses for the purposes of MAID. Now, if you look across the world, very few physician-assisted dying frameworks allow for mental illness as a sole criterion for MAID. The only ones allowing it are Switzerland and the Benelux countries, and now, as of 2023, Canada is slated to as well. So what about this issue of discrimination? Is that discriminating against people if most MAID frameworks or physician-assisted death frameworks don't allow it for mental illness? Well, I'll remind everyone that in terms of discrimination, equity does not mean that everything is or should be treated the same. It means the principle of treating things for what they are. And if things are different, perhaps they should not be treated the same. And with that in mind, are the differences in mental illness things that warrant different consideration? So these are 3 areas that I would suggest initially do warrant different consideration. And you'll notice that I'm saying in the first one, impact on decision-making while competent. Capacity alone is not a sufficient safeguard for what we're talking about here. And then I'll get to the other 2 briefly. But I would state all 3 of these as being the current state challenge. In other words, how do we assess somebody in front of us in those domains? And we know, obviously, that there are many potential cognitive distortions that occur when we suffer from mental illness. And the traditional cognitive triad of I'm bad, the world is bad, and the future will be bad is common. Our resilience emotionally to any sorts of stressors, large or small, things we might normally bend and adjust to, our resilience gets fractured and broken when we have significant mental illness. And we tend to discount the positive and focus on the negative. And when you're thinking about somebody's will or desire to live, when they are in a state of suffering, think about what that means, especially as we're seeing even neuroscience showing us that there are physically areas in the brain that function differently. So this is something that looks at changes in functioning that quite literally may make it impossible for people in a state of depression to anticipate a future. Imagine what that means when you're trying to decide if you should be here or not in a state of depression, or whether that medication that helped you 3 years ago might help you this time, but you don't want to take it this time. The issue of suicidality, I'll speak on more later, but I will point out that, of course, mental illnesses are the only illnesses where suicidality is a potential diagnostic criterion of illness. So think about how all these things affect people. And lastly, on this section, think about how we as providers provide MAID. I'm not going to focus much on this, but I will point out that even in Netherlands, there's a huge difference in who provides MAID for mental illness versus who provides it for other medical illnesses. And the vast majority of assisted deaths in Netherlands for mental illness are not provided by people involved in the patient's care. They go to these end-of-life clinics. And largely that's because the people involved in the patient's care refuse to participate. This contrasts with less than 10%. It's between typically 5 to 8% of the total euthanasia cases in the country going to these clinics. So, myth number 1, mental illness and other illnesses are the same for the purposes of MAID. Mental illnesses are legitimate illnesses. It's not about stigmatizing them, but they are not the same on issues related to MAID. Now, unfortunately, these kinds of myths are like a hydra. You chop off one head and another grows. And a related myth is that mental illness for MAID would be for relief of irremediable conditions. Well, let's look at that. You know, I've focused on this a lot since irremediability is supposed to be the primary fundamental foot in the door safeguard to our entire MAID framework. So the simple question becomes, not even can mental illnesses be irremediable, but can we predict them to be irremediable for MAID assessments? And what are we predicting to be irremediable? Is it illness symptoms, or is it also other psychosocial suffering that we know our patients with mental illness disproportionately have? So I've written about this. One of the nice things about these virtual Zoom things, the probably only nicer thing than meeting in person, is that you can take screenshots or view afterwards for the references. So I won't speak on things that the references are provided for, but this is a paper I wrote in our journal on what irremediability actually means in mental illness. And you know, I was on this panel that studied MAID for mental illness for over a year and came up with a 250-page report. And more important than the findings were the areas of disagreement, that even after all this, there were significant disagreements amongst the panelists about various issues. But one thing that was clear, there was no evidence in the world of being able to properly predict irremediability in mental illness. Back in the old days, I was president of CPA at this time, and we actually said to our government that there's no established standard of care for defining the threshold when psychiatric conditions should be considered irremediable. Our Centers for Addiction and Mental Health, one of our probably most prestigious academic institutions, has concluded there's simply not enough evidence to ascertain whether a particular individual has an irremediable mental illness. And here's another reference you can look at that looks at the evidence as well, that was reviewed more recently in February 2020. Interestingly, even some of the groups that have advocated to expand MAID for mental illness, such as the leadership of our Quebec Psychiatric Association, they acknowledge that irremediability, that it's possible that a person who has recourse to MAID, regardless of their condition, could have regained the desire to live at some point in the future. And then they suggest that assessors will have to answer this ethical question each and every time they evaluate a request, which is, to me, quite striking. Our law did not say that a person has a grievous and irremediable condition if, in the ethical opinion of each assessor they do. These things should be based on science or evidence, not hand-waving, in my opinion. And so this myth that MAID would be for relief of an irremediable condition also falls. It would not be. And if it's not for an irremediable condition, what is it for? Leads to our next myth, which is that expanded MAID is not suicide. Now, when we look at this, the power of language comes into play. That, Canada coined the term medical assistance in dying instead of physician-assisted suicide or physician-assisted death for a number of reasons. One is it actually isn't just physicians. Physicians or nurses are able to participate in Canada. And the issue of in dying suggests that someone is dying. And perhaps that's reasonable when you coin a term to assist people when death is reasonably foreseeable, but is it the same when you provide death to non-dying people who wish to die? The evidence found by the CCA was that for terminal conditions in North America, as it had been provided so far, and in other places that provide assisted death for terminal conditions, you can distinguish often and usually the motivations for death from traditional suicidality, and they can include issues of autonomy and dignity. However, once you expand MAID, once it's for broader disabilities and psychiatric euthanasia, then you can't distinguish these people who seek it from traditionally suicidal populations, and they have shared characteristics of ambivalence, demoralization, ruminative depressive despair, etc. And so it's not for an irremediable condition. It's for somebody who's having other life suffering. And as mentioned, people with mental illness tend to have even more of that. And so the language issue really comes into play. And it troubles me that many of the expansionists in my country refuse to even use the word suicide. They say, no, it's not the same. Well, expanded MAID for non-dying literally is assisted suicide. That's what the word means. And when we compare the vocabulary used in MAID to what media's reporting guidelines are in reporting suicides, look at the stark contrast. Media reporting guidelines, we're not supposed to glorify suicides. We're not supposed to go into excessive details about them. We're not supposed to try to justify that it was a reasonable suicide. That is all the language that people who have advocated for expanded MAID actually use for MAID. It's often romanticized, and it's something where it's presented in ways that actually are totally at odds with how we report suicides in the media. So, next myth. Expanded MAID is assisted suicide. What about this one? And this is where we get to the different impacts on different populations. Myth that marginalized populations are not at risk. Now, what is that based on? Partly it's based on the fact that we're talking about two different groups. And if you do look at the evidence of people who get MAID for terminal conditions, and North American MAID up until now, you actually find that the people who seek it are from higher socioeconomic status classes, better educated, and more likely to be white. When you look at psychiatric euthanasia, it's very different. Then people have unresolved psychosocial suffering and lack of socioeconomic resources. So it is a different group. And this slide to me illustrates that, we're talking about disparities in death. We have disparities in life all the time. This is a slide from early days in Toronto and COVID. And for long story short on this, the one on the left represents the postal code areas of people with lower socioeconomic status in darker red, and it coincides with the people who had more morbidity and mortality from COVID. At the same time, the one on the right reflects the more affluent neighborhoods that had the highest rates of immunization in initial vaccine rollout. And this was not from vaccine hesitancy, it was from access. So there are differences in life throughout that affect things. And when we look at what leads to death in various marginalized populations, no surprise to anyone here, we know that First Nations tend to have much higher suicide rates than other groups. And Statistics Canada has even acknowledged that this is due to socioeconomic characteristics like low income, poor labor force status, level of education. It's not mental illness related. And we find similar discrepancies in suicide rates for other marginalized groups. LGBTQ2 spirited have higher rates, etc. So it begs the question, what suffering is leading to MAID and especially expanded MAID? So the illness might be a foot in the door, but it's cumulative with life suffering, problems with lack of access to care, a false assessment of irremediability, potentially leading to death. And that is in fact what we find. So this study looked at all of the cases of psychiatric euthanasia in Netherlands. And unlike assisted death for terminal illnesses, which has a 50-50 gender balance typically. Here you have a 2-to-1 gender imbalance, a gender gap, as you'd say, of 2-to-1 women seeking and getting psychiatric euthanasia, which parallels our 2-to-1 suicide attempt rates. You also have ongoing psychosocial isolation and suffering, and in 1 in 4 cases, disagreement amongst consultants. So next myth to fall is the one that marginalized populations are not at risk. They are, especially as MAID expands. And now I have 2 more, and we'll end on those, but this one is a significant one, that due diligence has been done. You know, you expect when a country goes through and implements laws that many steps of due diligence have been done. I don't believe they have been in Canada. Parliamentary-wise, we were supposed to have a 5-year review that was bypassed. Very unusually, that Quebec court ruling was not appealed by the federal government, and instead it went to an unelected Senate for deliberation, and they suggested putting in a sunset clause on our exclusion to mental illness for MAID. And after 1 year, the government actually last minute changed and added the sunset clause to ensure that MAID would be allowed in 2 years. And there was confusion about this in the parliamentary process. You know, I found it very striking that even a week afterwards, several of the Liberal members who voted for this actually were writing back to constituents, essentially saying, no, we're continuing to exclude MAID for mental illness, when in fact they had voted for the opposite. So what about input from expert organizations? Heard the deliberative process that your group is under, which is excellent. The American Psychiatric Association holds that psychiatrists should not prescribe or administer interventions to non-terminally ill persons for purpose of causing death. And the Australian College and New Zealand College similarly does not agree with psychiatric euthanasia. What about my own? And this is very troubling for me. You know, after 2 years, we had a task force back in 2016 that was sunset in 2018. Then for about 2 years, there was no consultation or engagement of membership. And unexpectedly, CPA leadership came up with a position statement March of last year that patients with a psychiatric illness should not be discriminated against and should have available the same options regarding MAID as available to all patients. And startlingly, months later, when there was concern expressed by many members, myself included, they had acknowledged that the statement was never even intended to examine whether psychiatric conditions are irremediable, and if so, how this should be assessed. Throughout this consultation process, which involved months, written submissions, oral testimony, the Canadian Psychiatric Association continued to claim to membership that it had no position, while stating publicly and in testimony that the exclusion of MAID for mental illness was inaccurate and stigmatizing, discriminatory, etc. You see the other things there. And I think most disturbing for me as a physician and a psychiatrist is that throughout this entire process on consultations on mental illness and death, the Canadian Psychiatric Association never once raised the issue of mental illness, suicide risk, mental illness related suicide risk, suicide prevention. In fact, the word suicide was not even mentioned once by the CPA. To me, that would be like a respirology association not mentioning smoking as a risk factor in consultations on lung disease. I do not understand it. And in fact, I would go further, and I have said this publicly. I believe that the CPA has abdicated its role as clinical experts, and in fact, flagged that openly. During Senate testimony, one senator asked, does the CPA agree with other experts that more research is needed in mental disorders prior to providing MAID for mental illness? And our president responded, I guess that's a legislative decision. So I'll leave you with some references here. I'll just leave these slides up for a few seconds so you can either screenshot or see them later. But many people, and these are mood and suicidology experts, have criticized the lack of evidence, as have I. Again, I'll leave the link here very briefly, and I'm almost done. But you know, in reflecting on Canada's debate about medical assistance in dying, in my view, evidence has already been provided of medically assisted death. Very briefly, this is not something that most psychiatrists, I believe, agree with. This is from the most recent study done in Ontario, the largest province. And here, although over 85% believe that MAID could be provided in some situations, the majority did not believe it should be provided in cases of mental illness alone, and strongly by a 3-to-1 margin, psychiatrists did not agree with that. So due diligence, I would say it has not been done. And now for the last about 4 minutes, I will go on to the last myth. And I think this is a key one. If you recall the myth of the Hydra, it had, there are various myths, but in many of them, it has one last immortal head that must be dealt with, or it keeps coming back. And to me, the immortal head of this Hydra is that expanded MAID is about autonomy. Why do I say this? Because this is the myth that has sold it to the public. It's about your autonomy and your right. And my view is it may increase autonomy for some, but evidence shows it does not for all. What suffering leads to expanded assisted suicide? And here's a reference that very recent one that goes over the sorts of things that people seek it for. And it's complex. These aren't the only reasons, but these are some of them. Perceived failures to live up to the expectations of others and being a burden to society, etc. And so it raises the question of what is autonomy? Autonomy is not a narrow concept. There are concepts of relational autonomy, the idea that various somatic oppression can be internalized and we might react to that. In other words, a choice one person makes in the same thing is not the same choice that someone else faces. This is a reference that just came out in the past week in Psychiatric Times, looking at the issue of autonomy. I'll leave it there very briefly. And this is a podcast in a Canadian media outlet. I have a small part in this, but this was largely about people who are seeking assisted dying for social suffering, that when their money runs out, I am going for MAID. And so ending on this, I won't speak to this, but the UN Rapporteur of Rights of Persons of Disabled has found significant problems in Canada about the kind of suffering that may be leading to MAID. And this is before our recent expansion. And they've actually suggested that concepts of ableism and ageism and other sorts of isms are influencing this. So, last myth, that it's about autonomy. In my view, it's actually not. It's about privileged autonomy. And yes, some populations may have the increased autonomy to die well after living a life lived well, but we will also expand and provide marginalized populations premature deaths, even when they could get better. And the link is there for you. And in conclusion, in 5 short years, we have gone from a MAID framework in Canada that was introduced to provide compassionate relief from a painful death to an assisted suicide framework providing death to escape a painful life. We've become the most liberal MAID legislation in the world with the fewest safeguards, surpassing any of the European countries. And regardless of anyone's opinion on MAID, evidence and due diligence have not informed our policy decisions. And my suggestion is we've gone from medical assistance in dying to socially assisted, or perhaps even abetted death, from MAID to SAD or SAS. I used to end these talks way in the early days in 2016 saying, where do we want the balance? With the notion that maybe we can find some sort of perfect balance. I no longer believe we can. And this is what's most disturbing to me. Our social contract means that the rights of one person can go so far, but when they affect someone else, maybe that should be taken into consideration. And with MAID, I believe we need to ask ourselves, which mistakes do we want to make? And are we going to risk marginalized populations for privileged autonomy? I wish that we weren't in Canada, but I fear that we are. And this is the last reference that I'll leave you with. It's from a recent piece I did in the conversation, and my concern that one day we will be issuing an apology for what we have been doing. So thank you very much for your attention. I'll leave this just for 1 second before stopping the screen share, so you can grab any additional resources. And I will turn it back to you, Dr. Clark.
Thanks a million, Professor Guind. Will you be able to make your slides available to participants?
Yes, absolutely.
Thanks a million.